This is John Watts. I'm a financial protection attorney in Alabama, and I'm very happy that you're here watching this video. You are watching this because you've either been sued or maybe a debt collector or what's known as a debt buyer is threatening to sue you and you live in Alabama. And so what we're going to talk about are the 5 options you must know about when one of those debt collectors or debt buyers sues you in Alabama. And so let me give you a disclaimer first of all. We're obviously not giving you legal advice because we don't know your particular situation. This is designed to give you a good overview of your options. Now, we're not going to go into a lot of details about exactly how does a lawsuit work, or if you defend the lawsuit on your own, how do you testify in court, any of those types of things. We'll have some additional videos that will go into different parts of this. But what we want to do in this video is give you the big picture of 5 options that you have when you've been sued. And we'll try to help you think through what are some advantages and disadvantages of each option. And let me tell you a little bit about myself so you know, in case you're sitting there going, well, why in the world should I listen to this guy talk about being sued? Well, my law firm defends on average between 5 and 10 people a month who live in Alabama who have been sued by a debt collector or a debt buyer. And these are typically lawsuits brought by LVNV Funding, Midland Funding, Portfolio Recovery, Calvary, Unifund, and then there are some smaller companies that also file suits. And then over the years, we have filed dozens and dozens and dozens of federal court lawsuits against these debt buyers, all arising out of a collection suit that they filed against our client. So we have a lot of experience with these guys, both in defending lawsuits brought by the debt collectors and also in suing the debt collectors or debt buyers in federal court. So our goal with this video is to help you understand the options so that you can move down the road in figuring out what's the right answer or the right option for you. So there are 5 options. Let me just run through those real quick and then we'll dive into each one. The first one is bankruptcy. Second one is to fight the lawsuit on your own. Third one is to settle the lawsuit on your own. Fourth is to hire a lawyer to fight it. And finally, hire a lawyer to settle the case. So let's look at this first option, and we call this the extreme choice of bankruptcy. Now, if you've been sued, you're probably getting all sorts of letters from bankruptcy attorneys saying, hey, we can file bankruptcy, Chapter 7, Chapter 13. We can make this go away. We can get you on a payment plan. And sometimes this is the best option. So let me give you a little bit of overview of bankruptcy. Chapter 7, if you qualify and you file it, will wipe out your debt. Chapter 13 is where you sort of gather all your debts up and then you make payments into court. And this can be by wage withholding, or it can be just you send a check to the court. But you do that for 3, 4, 5 years, and then the court will pay each one of your creditors. And so the option of bankruptcy, the advantage is if you can file particularly Chapter 7, that's what I'm going to focus on, it'll wipe out this lawsuit. You will not have to pay any money on it. The downside is you had to file bankruptcy. That's on your credit report for many, many years. Also, when you apply for any type of credit, generally there'll be a question, have you ever filed for bankruptcy? You got to be honest and say yes. So bankruptcy is something we use when there are really no other choices and everything is falling apart. I usually ask folks that I'm talking to, hey, look in the future 2, 3, 4 years. Do you see things getting better, staying the same, or getting worse? Now, if they say getting worse, okay, well, let's look at bankruptcy. If they say, oh man, I went through a hard time and I'm almost out of that bad time period. Well, we sure hate to file bankruptcy and then wreck our credit for quite a number of years. So bankruptcy is an extreme option. When it's necessary and appropriate, it's extremely effective. But I see people use this when it's not needed. And that would be kind of like, I've used this example for if my little finger is broken and I say it really hurts, and you go, I got a great solution. I'm going to chop off your arm. Well, that makes my little finger not hurt, but it's probably too extreme of a solution. And sometimes we see even lawyers who specialize in bankruptcy. It's kind of like that old saying, to the man holding a hammer, everything looks like a nail. Well, hey, the one solution to everything is bankruptcy. No, bankruptcy is one option, and it might be the best option for you, but you have to really sit down and count the cost of it. Well, the next two options we're going to look at are really do-it-yourself options. You do not need to hire a lawyer, and so that's one big advantage of these because there's no lawyer fee. So option number 2 is you fight the lawsuit on your own. And what that means is you respond or you answer the lawsuit in court within the time periods. And again, we'll get into those details in a different video. But you respond to it on your own. And then ultimately you go to trial. And the biggest advantage of this is, again, there's no lawyer fee. The biggest disadvantage of this is you don't have a lawyer going with you. So you're facing a lawyer on the other side, but you don't have a lawyer on your side. Now, I'll give you some suggestions if this is of interest to you. First of all, your objective in fighting this on your own is you want to win the case. And that's also true if you hire a lawyer to fight it. The objective is to win the case, because if you win your case, it may be that you can file a lawsuit against the debt buyer who sued you for violating the Fair Debt Collection Practices Act or other laws. And so we want to win the case because that will help us with our credit reporting. It may give us the ability to sue the debt collector and recover money damages. And once you win the case, assuming there's no appeal, then you're done with that debt collector on that debt. They should never bother you again. Now, we've had situations where our client has won the case and then they get collection letters from the same debt collector. Well, we have a simple solution. We sue in federal court, the debt collector pays money, and then they leave you alone. We've even had the same client be sued twice by the same debt collector, even though the client won the first case. Well, obviously that debt collector that does that, there's a very heavy price to be paid for that. But this is the whole objective of fighting on your own as you want to win. So a couple resources. If you want to go this route, we have a report. It's about 25 pages or so. And it discusses the 7 mistakes that are often made when people testify in these types of cases. So by looking at those 7 mistakes, you can go, okay, well, I'll try to avoid those, and then do the opposite. The other thing is, and this is really, really critical, and I give this advice to everybody that I talk to who's decided to do this on their own, to fight it on their own. Most will ignore it, and most will lose their case. Now, you can decide whether there's any connection there. But here's what you need to do. You need to call the judge's office, whichever judge has your case, and say, hey, I have a case set on, October 24th, whatever. And it's a small claims case, it's a district court case, whatever it is. Do you have any cases like that set the week before? And normally the judges, particularly in small claims in district court, they have trials set on the same day, usually the same time every week. So they say, sure, you can come the Monday before. And what I want you to do is to go to the court. And what that'll do is, first of all, you make sure you find out where it is. You make sure you understand how to get through security, the time it takes. And then find the courtroom and then sit in there and just sort of soak it up. Understand what the feeling is of that courtroom. Watch the judge. How does the judge interact with people? Is the judge very strict and formal, or is the judge pretty laid back? Is it crowded in there? I've been in some courts where we had hundreds of people set, hundreds of cases set, so there's hundreds of people in there. It's very difficult to hear. Well, if you realize that's the situation, you might want to definitely get there early and sit up front so you can hear. Other times, there's just a handful of people. What do people do when the judge walks in? Do they stand up? Do they stay seated? Just figure out about your judge. Watch what happens. Watch what your judge does when somebody says, what the judge will do is say, all right, I'm going to call the docket Smith v. Jones. And Miss Smith raises her hand. Judge, I'm here. Mr. Jones raises his hand. Well, what does the judge do? Does he take him immediately to trial? Does he tell him to go in the hallway and talk? What does he do? The purpose of this is so that when it's your day, your trial, you're not getting there late. You're not getting surprised by how long it takes to get through security. You know where you're going, and you've been there before, and you know how the judge is. And so if the judge, and this is very typical, calls your case, you stand up, raise your hand, say, Judge, I'm here. The judge will say, have you talked with this lawyer for Midland Funding or portfolio recovery? And you say, no, Your Honor. And the judge will typically say, well, I'm going to give you a chance. You guys can go in the hallway and talk, see if you can work it out. Well, that won't be a surprise for you because you'll have seen that the week before. It's very, very important to do this. I have some people that say, well, John, I don't have time to do that. I'm very busy. Okay. Well, this is to increase your chances of winning. And remember this, whatever we do in life, we're spending time or we're spending money. And if you say, well, I want to handle this on my own so I don't have to spend any money on a lawyer, that's fine. But make sure that you're willing to spend the time to give yourself the best possible chance of success. And the final thing I'll say about this option, fighting it on your own, this is much harder in circuit court than in district court or small claims court. And I think we'll have a follow-up video where we go into more details. But just understand, if you're trying to do this on your own in circuit court, the level of complexity goes up. Well, the third option, again, doing this on your own, is to settle the case on your own. So this is where you talk to the collection lawyer and you say, look, let's work this thing out. There's basically two ways that this will happen. One is you pay a lump sum. And typically, not always, but typically, you can get the other side down to about 50 cents on the dollar. Now, they may start off and say you got to pay us 90 cents on the dollar. But normally, if you negotiate, you can get them down to around 50 cents on the dollar. So if you're sued for $8,000, you're probably looking at a lump sum all at once, $4,000. Well, if you cannot do that, or if you just don't want to do that, maybe you want to keep your cash, then you make monthly payments, and now you're normally looking at the whole amount being due. So if you paid $250 a month, that's $3,000 a year. So if you are sued for $6,000, that's about 2 years you're going to be paying. Well, what are the advantages and disadvantages? Well, one advantage is, again, there's no lawyer fee. And another advantage is once you pay it, you're done. Now, you do have to make sure that while you're negotiating, there's no default judgment against you. So you still want to protect yourself, get your answer filed in the right amount of time. But once you make all your payments, you're done. Now, a disadvantage is normally this will stay on your credit reporting. So if you're sued for $8,000, you pay them a lump sum of $4,000. Normally, Midland Funding, Calvary, Unifund, LVNV, whoever it may be, they're still going to be on your credit report. Now, they should update it to show you owe zero. You do have to watch for that because some of these guys are kind of bad about not doing that. But just understand that normally they will not agree with you to delete the credit reporting. Another disadvantage is, and let's stick with our example, sued for $8,000, you pay $4,000. So the debt collector will say, well, we forgave you $4,000. Well, that may be considered income to you. And so you may get a 1099 the following January saying you have $4,000 in income from debt forgiveness. So you have to understand how that will work. And so in looking at these first two options, besides the bankruptcy, you fight this on your own, you settle it on your own. Those are often legitimate options for you to consider. Now, what about hiring a lawyer? Because there's an old expression that says, if you represent yourself, you have a fool for a client. That normally is true. I will say this, in district court and small claims court, it often can be, if you're willing to work, willing to spend the time, it may be a good option for you to fight the case on your own. But let's say you go, well, you know what, I want to hire a lawyer. Well, you hire a lawyer to fight the case. And you really have the same objective as if you're doing it on your own. You want to win the case, because if you win the case, in our view, that means you do not owe that debt to that debt collector. It means that debt collector cannot be on your credit report. And then we start to back that sort of thought process up and say, well, wait a minute, if I don't owe the debt, but the debt collector's been reporting on my credit report for a year I owe it, that seems like a problem. And they sued me and I didn't owe it, and they sent me collection letters and I did not owe it. So there are some good consequences when we win these cases. So what is the, let's say, the biggest disadvantage of hiring a lawyer is you got to pay a lawyer fee. The advantage is you would at least expect to have a better chance of winning. Now, whether you do it on your own or hire a lawyer, nobody has a guarantee they're going to win, because that's not your decision. It's not my decision if you hire me. It's the judge's decision. But you should at least feel like you have a better chance of winning hiring the lawyer. If you don't feel that way, then why hire the lawyer? So you want to talk to the lawyer and find out what's their experience. Do they teach other lawyers about this? How long have they been doing it? What's their plan? And if somebody says, well, you know, I've got this secret approach and I'm not going to tell you until you give me a check, I don't know. That would make me a little concerned. I would want to know, well, at least in general terms, what's the process and what's the thinking here for how we're going to be successful in this, because I got sued by Midland Funding or Asset Protection or whoever it may be. What's the plan to defend me? So definitely ask questions so that you feel confident and comfortable in hiring that lawyer to fight. Now, the final option is you hire a lawyer to help you settle the case. And that is, the lawyer will then negotiate for you and find out, okay, well, what is either a lump sum or a series of monthly payments that you can make so that the debt collector, the debt buyer, will agree that the case is settled. Now, again, you've got to look at what's the cost of doing that in terms of lawyer fees. And then how does that compare with you doing it on your own? In other words, are you getting some advantage by hiring the lawyer? Maybe it's you're spending less total, or maybe you're getting credit reporting deleted, or maybe there's some other advantage that you're getting. So you have to factor all that in. Again, ask the lawyer, what's your plan on this? Now, I'll tell you, for us, for my firm, Watson Herring, and we represent people all over the state of Alabama, and we typically give the debt buyer a choice. We get in the case, we file an answer. So when we've been hired, we file an answer, and then we go to the debt buyer and we say, look, it's very simple. We can either continue on this course and we will fight the lawsuit and we'll go to trial. And there's no secret here, no surprises. If we win, we're looking at seeing if we can sue you, the debt collector, the debt buyer, for this lawsuit. Or you can drop the lawsuit and get it off of our credit report, and everybody goes away. Now, sometimes they choose one, sometimes they choose the other. I am not, in most situations, a big fan of having my clients pay any money, because my experience in handling hundreds and hundreds of these cases is that at least when we're involved, they promise us in every other case they can prove it, but when we're involved, we see the debt buyers, the debt collectors really struggle to prove their case, to prove they own the debt, to prove that they filed the case against the right person and that this was done in the right time period. In other words, did they violate the statute of limitations by filing this case too late? And so we give them that choice. We can continue like we're headed and go to trial, and we'll see who wins and who loses, or everybody can go away. Our client pays no money, and our client doesn't sue the debt collector, and the debt collector drops the lawsuit with what's called prejudice and gets it off of our credit report. And so that's the choice that we give to the debt buyer or the debt collector. Now, as you think about these 5 options, what's the best for you? Well, you really have to sit down and explore each one of these. And normally when we do that with somebody, we can pretty quickly get rid of at least 3 of these and say, okay, look, here are your legitimate options. You can fight this on your own, or you can hire us. Sometimes bankruptcy may be the only legitimate option. Sometimes settlement's the only legitimate option. Somebody says, I want a guarantee that I can resolve this case and all I have is $50 a month. Well, okay, we don't want to do bankruptcy. We don't want to fight it on our own because they want a guarantee. They don't need to hire us because I can't guarantee them. And they want to pay $50 a month. Well, you do a settlement. Somebody else says, you know what, I've got to have this off my credit report. Then the best option may be hire a lawyer to go in and fight it and give that option to the debt buyer. You can drop the case and get off my credit report, or we can go to trial. So you have to decide what's best for you. Now, I do want to take this moment and congratulate you because you've gotten this far in the video. And most people, when they start a book, they don't get past first chapter. They start a video, they kind of fade very quickly. But you've gotten this far, so congratulations for taking action, because the biggest danger, and we'll talk about this in other videos, but the biggest danger when you've been sued by a debt collector or debt buyer is doing nothing. And when you do nothing, they win. They get a judgment against you. So congratulations. Now, if you have questions, we have a lot of articles, a lot of videos on our main consumer website, alabamaconsumer.com. You'll see there's kind of a welcome video, and then to the right of the video, there's some buttons if you're interested in foreclosure, credit reports, but what you're probably going to be interested in is that you've been sued by a debt collector. So go there, there's all sorts of videos, articles, you can read all about this. Now, you may say, you know what, I'm ready to talk. I want to, talk with a lawyer directly and find out which option's best for me. And that's great. You can call us, 205-879-2447. And when the receptionist answers, just say, you know what, I've been sued, or I'm about to be sued, and I've watched the video on the options, and I'm ready to talk to the lawyer, and generally that's going to be me, my name is John Watts, about my options. And then they can set it up, or you may speak with somebody else in my office, usually Carolyn, and she'll set us up a time to talk either by phone or in person. And then we can go over your options. And for a lot of people I meet with and I talk to, I say, you know what, your best option is to do this on your own. You don't need to hire a lawyer. But if I think you need to hire a lawyer, I'll tell you that, and I'll tell you exactly what the cost will be and help you think through whether or not that makes sense. So I want to thank you for watching this. I appreciate your attention. If you have found this to be helpful, feel free to share it with Twitter or Facebook, or you can like it, put a comment on it. That all helps us to get the word out to people, because the biggest danger for folks when they've been sued is they do nothing because they think, I don't have any options. If you think you have no options, it'll freeze you. I'm the same way. If I think I have no options, then I'm going to say, well, there's nothing to do. But you've taken action. I want to encourage you to continue to take action, whether that's filing bankruptcy, fighting it on your own, settling it on your own, hiring a lawyer, whether it's us or somebody else to fight it or settle it. Just want to encourage you to take the action. And if we can help you in any way, definitely get in touch with us, alabamaconsumer.com or 205-879-2447. Thanks again for watching this, and I hope you have a great day.